This is Liberty Law Talk, part of Liberty Fund's online library of law and liberty. Your host is Liberty Fund Fellow Richard Reinsch. Our web address is libertylawsite.org, where you can subscribe, comment, find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org. Today we are discussing with Mark David Hall a new book he has edited for Liberty Fund called The Collected Works of Roger Sherman. Mark David Hall is the Herbert Hoover Distinguished Professor of Politics and Faculty Fellow in the William Penn Honors Program at George Fox University. He's also no stranger to Liberty Fund books. He's the co-editor of our Collected Works of James Wilson, and also with Daniel Dreisbach, a volume we published called The Sacred Rights of Conscience, Selected Readings on Religious Liberty and Church-State Relations in the American Founding. He's also the author of a study called Roger Sherman and the Creation of the American Republic. Professor Hall, welcome to the program.
Thank you very much for having me, Richard.
So this volume that you've done, The Collected Works of Roger Sherman, represents something quite new in American founding scholarship, in that it's an attempt to put forward a lot of writings that Roger Sherman made in a variety of areas, and bring that to readers, to scholars, with the hope that we might revive thinking and writing on Roger Sherman. But tell us, or sketch for us, who was Roger Sherman, and why is he an American founder that we need to recover, and one that has been relatively ignored up to this point?
Sure, happy to do that. Well, Roger Sherman was a very important American founder. He's the only founder who was involved in forming and signing almost all of the key American documents out of the founding era, including the Declaration of Resolves, the Articles of Association, the Declaration of Independence, the Articles of Confederation, the Constitution, and the Bill of Rights. So he was not only present for the formation of all those and for signing the ones that you could sign, but he was a very important participant. And as our interview goes on, I'll try to make an argument that he had a pretty tremendous impact on all of these documents. He is not that well known, but of course most founders aren't that well known. Most people tend to know 5 or 6, 4 of whom ended up becoming president of the United States, almost all of whom were flashier, almost all of whom left a tremendous paper trail that scholars could work with, right? So Madison and Adams, Washington, their papers go on for 80, 90 volumes. This collection is unique. This is the first real academic critical publication of the Collected Works of Roger Sherman. It's one volume, a very hefty volume, about 800 pages or so. But this volume pretty much contains all of his key writings. There's another 2 volumes I perhaps could have produced, but the writings that would have gone in that would be pretty, not all that interesting, legal business dealings and this sort of thing, things that would be of interest to a few academics but not to the general reading public.
So you mentioned this sort of distinguished career in the American founding that Roger Sherman had, and it spans the entire period there. One of the things that really kind of stands out in my mind is someone who is involved it's almost like he knows very well from my read of some of the selections of this book what's going on in the pamphlet debate and the arguments over sovereignty and the status of the colonies within the British Empire, and he's participating in largely in newspaper debates, the relationship between not just the crown and the colonies, but he understands sort of the crucial political thought there and legal thought that's giving rise to these debates. But what types of contributions do you think that he makes in terms of political thought as we get into, because mentioned he's part of the drafting of the Articles of Confederation, the Declaration of Independence. He was on the draft committee the Continental Congress appointed. He's in the Articles of Association. So is there sort of a Roger Sherman political thought, the way we can say there's a Madisonian, Jeffersonian, or Hamiltonian school of thought? Is there something there that we can piece together, which is important because we throw around these terms founder and framer indistinguishably, but they do mean something. And I think Roger Sherman, we can claim, was a framer he was involved in these documents.
Yeah, I do argue in my book published by Oxford, and I think it comes through in the collected works, that he does have a coherent political theory. I should say that he was not college educated, as opposed to many of the, but not all of the famous founders that we know. But he was certainly self-taught. He eventually apprenticed as an attorney and became an attorney himself, so he was familiar with these legal arguments. He embraced the Patriot cause early on in 1766, right after the Stamp Act Congress. He has a great letter where he's reflecting on different things that the Crown or Parliament might do that would break the relationship between the Crown and the American colonies. John Adams, traveling through New Haven, had a chance to chat with him in 1773 and said, basically that Sherman's right on all accounts. He understands these arguments. He understands actually that James Otis gives up too much in his defense of American rights. So yeah, he understands the debates as we get into the discussions over the Constitutional Convention. He has a very definitive approach to how the nation and the state should be related, what sort of power the national government should have. An approach that I actually find I like quite a bit more than a number of the other founders I've worked on, including James Wilson and James Madison and others. If I were to try to describe Sherman's political theory, I would say he is an excellent example of the Reformed or Calvinist tradition of reflecting on political matters, a tradition that you can trace back to John Calvin, but which is developed almost right away by, say, a John Knox or a Ponier or a Buchanan, a tradition that is very, very sensitive to the threat of tyranny, a tradition that says inferior magistrates or the people themselves have a God-given obligation to rise up to resist tyrants, that people have natural rights, that government should be limited, and that we should be very, very careful of concentrating power. And these Reformed thinkers are writing this well before John Locke writes the Second Treatise. We all often attribute these ideas to John Locke, and I don't mean to minimize John Locke at all, but I just want to suggest that Sherman does kind of shine a light on this tradition that is very, very powerful. It's powerfully present in early America. 50 to 75% of white Americans in the founding era are reasonably called Calvinists, and Sherman has drank deeply of this well and is drawing from this tradition as he engages in state government and at the national government on all these various issues.
So on this thread, you have included in this volume several sermons, I think, that Roger Sherman gave. You also have, maybe you can talk about this, selections from some of the almanacs he drafted, which were widely circulated, I take it, and which are full of religious, theological meditations and reflections. So, I mean, I think so. You're saying we have someone whose political outlook would have been heavily influenced by Reformed theology. Would he just sort of, he just would have breathed this in, I suppose, in church, in conversation, learning, etc.?
Yeah, exactly. He was raised in this tradition. He was in the South. Anglican gentlemen would oftentimes be appointed to positions of leadership simply because they were gentlemen, aristocrats. In the North, in New England, joining a church was incredibly difficult. You had to convince the elders that you had this real conversion experience and your life had been fundamentally changed. And then to become a church leader was all the more difficult, right? They wanted only the most pious, committed Reformed Christians to lead these congregational churches. Sherman early on joined a church, was appointed to be an elder, and so was involved at the church level. His pastor later in life was Jonathan Edwards Jr., the son of the famous Jonathan Edwards. Roger Sherman himself possessed almost everything that Jonathan Edwards had published that was available to him. He had read this. He engaged with Samuel Hopkins in sophisticated theological debates. Samuel Hopkins was a new divinity minister of some fame in the late 18th century. You're right. He wrote just one sermon, which he published, but he has plenty of letters. He writes to John Witherspoon and addresses the question of when it's permissible for Christians to divorce and this sort of thing. Yeah, so someone who's thoroughly and deeply steeped in the Christian tradition broadly, in this Reformed Protestant tradition more specifically. Now, some of this would be of interest primarily to historians of American church history, and I think there's things in this volume that would be of interest to them. But for our purposes, I would suggest that there's also this tradition of political reflection within this Reformed tradition that informs his participation in the War for Independence, the creation of the Constitution, the drafting of the Bill of Rights. And here's where we can see some clear payoff for our American constitutional tradition.
Yeah, well, interesting here, and I don't want to make a comparison or leap to a conclusion that's too easy or too simple. So Roger Sherman, involved in the Constitutional Convention, as you note, spoke more than any of the delegates with the exception of 3, and may have spoken more, but he had to leave for a week during the course of that summer in 1787. What types of the contributions does he make? I mean, he's most noted for the Connecticut Compromise, so we can see in that a response to the antithesis to James Madison and the Virginia Plan and the idea of a very strong national government premised on majoritarian political institutions in a certain respect in the federal government, and that he's now insisting on the equality of states need also to be represented. So maybe talk about that and what that sort of represents and why he reacts the way that he does in the convention.
Oh, that's a great question. So he does arrive a day or two after the proceedings begin. James Madison, of course, famously lays out his Virginia plan. And I think it's useful. I don't want to take anything away from James Madison, an incredibly important, influential founder whom I love in many respects. But you think about the Virginia plan. The Virginia plan would have pretty much just had a House of Representatives that was proportionally based. This House would then select an upper house, so there's no equality of the states or no direct way for states to elect or choose members of the national government. And this national government would have had a plenary grant of power. It would have had the ability to do whatever the national government decided it wanted to do. And then, of course, an executive chosen by the lower and the upper house. Roger Sherman arrives a couple of days late, and he says, "You have got to be kidding me. We cannot give the national government this much power. We cannot give the national government a plenary grant of power." And so early on, within 5 or 6 days of the debate starting out, he says we have to enumerate the national government's power to things like national defense, international affairs, the regulation of interstate commerce. And he continues pounding on this for the entire convention. And in the final analysis, I think we could say he deserves a great deal of credit for Article 1, Section 8, this enumeration of the national government's powers that kept the national government within boundaries for 150 years or so. Of course, things went apart in the 1930s, but we can hardly blame that on Roger Sherman. Sherman, of course, as you point out, he does understand that we need a stronger national government. He understands that a lower house based on proportionality is reasonable, but he also insists that we have to have the protection of the states, and so he does insist on the equality of the states. He, with Oliver Ellsworth, pushed the Connecticut Compromise, which provides for proportional representation in the House, but equality within the Senate. Very significantly, he also says this. He says we have to have the state legislatures choose the senators so that the senators are representing their states as states. If we do not allow this, if we allow the people of the states to elect the senators, then we might as well kiss federalism goodbye. And, of course, that's exactly what happened in the early 20th century, where we passed a constitutional amendment to give the people of the states the ability to directly elect their senators. And so I think Sherman was very prescient on this respect. Once Sherman started winning a lot of these battles, one of the things you see, interestingly enough, for people like Alexander Hamilton and James Wilson start pushing a really, really powerful chief executive, a president. Sherman is incredibly fearful of executive power, and he fights them on every level. He wants a president selected by Congress annually who has almost no power, not the power to declare war or the power to make war. And I just say that all to point out that he doesn't win every battle. He actually lost a lot of those battles. Wilson and Hamilton didn't get their way, but they actually won more of those battles than Sherman won. But when I look back on American history over the last 200 years or so, I actually wish Sherman had won more of those battles and that we had a more limited executive than we end up with. So Sherman, incredibly influential. There was an article in the American Political Science Review a decade or so ago that looked at Sherman and Madison agreed on a number of issues, but when they disagreed, the authors of this article looked at who won the battles, and Sherman won a lion's share of those battles. When Madison and Sherman disagreed, it was Sherman that came out on top. And again, I'm not trying to take anything away from James Madison. I just want to suggest that if you read through Fran's debates of the Federal Convention, you can see that Sherman is an incredibly active and influential player in the creation of our Constitution.
Yeah, no, you mentioned the article in the American Political Science Review that would have actually that waded through the convention and noted wins and losses on contested questions. The question that comes to my mind, or an observation, so we easily shorthand say James Madison is the father of the Constitution. He does. I think he loses something like over 40% of the time, or something like something. I read something to that effect in the Constitutional Convention, and yet scholars, though, for the most part, I mean, if we look at the weight of the evidence, really seem to focus on the Federalist Papers. I think much more so than the Constitutional Convention. I mean, there've been some great books on the convention analyzing it, but it seems to me we sort of think in terms of the political thought of Publius, and we think about Madison, or we think about Hamilton, but someone who is engaged in sort of this workmanlike approach, as Sherman was, seems to have been dismissed or forgotten, or more readily forgotten. Of course, he didn't leave behind anything, long essays, reflections that Madison or other founders wrote, but yet there he is in the middle of this.
Yeah, I think this is, from my perspective, part of the problem, and my PhD is in politics, but I think you do see a divide here. I think historians, people with PhDs in history, are far more likely to recognize in the American founding it's a very complicated process, that the convention was messy, that there are lots of players and lots of compromises being made, and that then, of course, there were lots of people writing the ratification debates, the anti-federalists, the federalists, but all sorts of different federalists. I think the argument for Publius is if you really want to find something approaching political philosophy in the American founding, coming from the American founders, probably it's one of your best sources, right? It's systematic, it's theoretical, it's very, very interesting. James Wilson's Lectures on Laws would be another document would come to mind. Sherman clearly doesn't leave anything like that, and yet I would point out that in the Federalist Papers, Madison eloquently defends some things that he opposed in the Federal Convention, and he's doing so at least in part for rhetorical purposes. Later on in life, of course, he goes back and forth between some of these things, so I think what happens sometimes is people like myself who are trained in political philosophy were so interested in finding works from the era that look like political philosophy that we focus in on the Federalist Papers and sort of neglect the fact that these were produced in a context that matters, the ratification debates in New York, and that they shouldn't be taken as political philosophy in the same way as, say, Locke's Second Treatise or Hobbes' Leviathan. But that doesn't mean they aren't important. And again, I don't want to take anything away from Madison. He is incredibly important. Maybe later we'll talk about why, in addition to political philosophers, the general public knows Madison more than, say, Sherman. And I think there's some interesting reasons that we might point to there. But I'm not sure if you want to go on and talk maybe about the Bill of Rights.
No. One question that comes to mind is, so in a way, the Constitutional Convention, if we think of the Virginia Plan as the thesis, and we get that sort of famous moment in the convention, I believe it's John Dickinson who says to Madison, you've gone too far because the reaction to it has been so great. And that's the antithesis. And then you have something like Sherman with the synthesis of states, of the Senate, of enumerated powers. And in a way, I see Sherman as trying to maybe unintentionally preserve continuity in that the colonists settled into colonies with distinct histories, distinct regimes, approaches to things, and that could not be erased as the Virginia Plan was proposing. It had to be kept and preserved and adapted under the new government, which Sherman acknowledged. Sherman was not an anti-federalist, and Sherman goes to the Constitutional Convention with express instructions to amend the Articles of Confederation, but he knows there are problems, and he's clear about this. But he goes, and it seems to me what he's trying to do, and maybe I'm putting too favorable interpretation on it, but it seems to me he's trying to work things out, but stay in a continuous line of development, as the colonies have known in self-government.
I think that's exactly right. So, again, these labels are problematic, but he's very conservative, and yet conservative of the stripe that says change is necessary, but it should be as incremental as possible. He's a huge advocate of states' rights, but he understands that we need a stronger national government that does need to be supreme in certain areas, international relations, interstate commerce. So there are some of these things where he's fully supportive of giving the national government more power. And he has a great letter that I have in this collection, basically saying the Constitution isn't perfect, but it's really, really good, and it's a lot better than what we have, so we should ratify it. And of course, you have similar letters by Madison and others. And this is one of the geniuses, I think, of the founding generation, and one of the geniuses of having the debates being closed, is these men with very different views could come together, argue their position strongly, compromise, and then come out, and most of them, of course, were able to support this compromise. Some didn't. You had some anti-federalists come out of Philadelphia and then, of course, percolate up throughout the states. And yet there was a robust debate there, and the nation decided to go in a particular direction, and most of the anti-federalists eventually fell into line, supporting this new constitutional arrangement that I think has done America pretty doggone well.
On the question of the Bill of Rights, it's interesting here. Roger Sherman, from what I've read in the book, didn't seem to think there was, much need for the Bill of Rights. And in fact, when James Madison tried to introduce the Bill of Rights in the first Congress, dismissed Madison or tried to dismiss Madison. Talk about that, because I think those arguments are also lost to present understanding of, when Sherman talks about it's the body of the document that matters and the incentives that matter within Congress, and that's actually what's going to preserve liberty as opposed to a list of rights. That also, I think, should be discussed.
Okay, super. Yeah, so Madison, of course, initially thought a Bill of Rights was not necessary for the same reason other Federalists argued it wasn't necessary. The national government has no power to pass laws infringing on the freedom of speech or press or religion, and so it's just redundant to say Congress has no power to do these things. Jefferson gets to work on Madison, I think changes his mind. Certainly running for Congress, Madison promises that he will try to get a Bill of Rights added. And so he starts pushing this almost right away in the first federal Congress. Roger Sherman's elected from Connecticut, so he's in the same body as well. And Sherman's argument is there are more important things to do. We have to organize the judicial branch, organize the executive branch. The sort of meaningless work on unnecessary rights, a Bill of Rights, can wait. But Madison does keep pushing the point. Just to look at the debates within this first federal Congress, which are laid out in the Liberty Fund version of the collected works of Roger Sherman, I think it's telling. Madison, again, I don't want to take anything away from him. We call him the father of the Bill of Rights. And yet, if you look at what he initially wanted, he wanted the Bill of Rights to be interspersed throughout the Constitution. Sherman almost right away said, no, we should keep the body intact and add the Bill of Rights to the end. And, of course, Congress eventually ended up going along with Sherman and not Madison. Madison gives this famous speech where he pulls from all the proposals out of the states and kind of lays out his version of what the Bill of Rights should look like. Every single amendment he proposed was either changed significantly or rejected altogether. And I say that just, again, to suggest that this is a body that is producing this document. It's not James Madison acting as a demigod, just imposing his view upon cowed colleagues. After the first debate in the House, there's a little committee put together, one member per state. Sherman's on that committee, as is Madison. The only handwritten draft of the Bill of Rights that we have is actually in Roger Sherman's hand, coming out of that committee. And so I say that just to suggest he's an active participant in the framing of these rights. There's in another debate in the House, a committee's put together to kind of put together what comes out of this. Sherman's on that committee. Madison isn't. The Senate makes significant changes to the Bill of Rights. Eventually, a conference committee is put together. The House delegation to this conference committee is led by Madison, but there's Sherman on this committee and John Vining. The Senate delegation is led by Oliver Ellsworth, of whom Roger Sherman was a protege. And so, again, I just point all this out to say Sherman was intimately involved in drafting, in creating the Bill of Rights. Madison was too. A host of other members of Congress were as well. And it's just critical to recognize that the Bill of Rights is a product of a body, not just one or two men. One of the ways this really cashes out, I think, in important ways, when you look at the Supreme Court and its interpretation, say, of the First Amendment's religion clause, the Supreme Court has been crystal clear that we have to understand the religion clause in light of the founders' views. And yet many, many justices only want to look at the views of Thomas Jefferson and James Madison. And my response to that would be it's fine to look at those two, although I'm not sure you should overemphasize Jefferson since he wasn't involved in this particular debate. And yet if you're going to take this approach to interpreting the First Amendment, you have to look at people like Roger Sherman, Elias Boudinot, Oliver Ellsworth, and a host of other founders that played important roles in crafting this document, and the other amendments, of course, not just the First Amendment.
Interesting question. I mean, and this is so. What you're emphasizing is something that we've forgotten: is we're a self-governing people, and men like Roger Sherman are a huge part of that. The Declaration of Independence is also instructive here. I mean, we could say, and I don't know. It's a question for you. So I mean, Jefferson obviously drafts. But it's amended. It's amended by the Committee on Drafting, and it's amended by the Continental Congress. What role do you think Sherman plays there?
Well, that's a great question. So you go back to 1776 and look at the congressional committees that are put together. There are three that sort of stand out to us, at least today, as being very significant. One is the Committee to Draft the Declaration of Independence, and Sherman is one of the five members on this committee, along with Thomas Jefferson. Another is the committee to draft the first national constitution, the Articles of Confederation. Sherman's on that committee. And the third and probably the most important committee at that time is the Board of War, the congressional committee kind of charged with fighting Great Britain. Sherman's on that committee as well. And I say that to say if you went back and looked at the Continental Congress in 1776, someone like Sherman would be one of the outstanding members of that Congress. He's on all of these critical committees. And so when you look at how the drafting of the Declaration of Independence works, Jefferson's only on one of those three committees. Jefferson has more time on his hands. To be fair, Jefferson is far more eloquent than Roger Sherman ever was. So he's given the task of drafting the Declaration of Independence, and he clearly comes up with the first draft. The committee comes back together, and we know of some changes suggested by John Adams and Benjamin Franklin, who are also on that committee. But the only way we know of those changes is because Adams and Franklin left records of their suggestions. So for all we know, Sherman might have been making suggestions as well and just simply not left a record of it. But then, of course, this amended draft goes to Congress, which tears it up even more in ways that Jefferson hates in some respects, and then ends up passing the Declaration of Independence. I say this all, again, I don't want to sound like I'm against any of these prominent founders, but to say that Thomas Jefferson wrote the Declaration of Independence is just really historically not the case. He came up with the first draft. The draft was changed in significant ways and ultimately approved by a body of 56 or so men. And so if we were interested in what the original meaning of the Declaration of Independence is, we have to go beyond Thomas Jefferson to look at Roger Sherman and these other American founders.
You know, it's interesting just thinking about the discussion we're having of reform political thought, theology. You know, there was a French scholar, Raymond Bruckberger, Images of America traced sort of this debate over the Declaration of Independence within the Continental Congress. And his conclusion is the two references we have to a personal judgmental God that are in the Declaration of Independence are added to it by the Continental Congress. So we don't know if Jefferson objected or not, or I don't know. But they're added, and there they are. And so that's the work of committee, or that's the work of a self-government there, not being just from the mind of Thomas Jefferson. So it's interesting, too. In the volume, there is a religious conscience bill, if I'm remembering, that Roger Sherman drafted for the state of Connecticut.
There is, yeah.
But a question that comes to mind is, so we're thinking about Jefferson, we're thinking about Sherman. So Jefferson lauded for the Virginia Religious Freedom Bill of 1800, but yet, or I forget the year, I should know that.
1786.
1780, yeah. But so the question becomes, how do those two compare? How are they each trying to defend the rights of conscience? Is there a substantial difference there?
Oh, that's a great question. So we've been talking only about Sherman at the national level, but he was intimately involved in state politics. In 1783, he and the aptly named Richard Law, another Connecticut politician, statesman, were asked to revise all of Connecticut's laws, sort of like Jefferson was down in Virginia. They came up with a number of interesting laws. I'll let you mention two before I answer your question specifically. At the urging of Daniel Webster, Connecticut came up with the first copyright law in the United States of America at the state level. Congress followed a few years later with the national copyright law. They also came up with a bill to end slavery in Connecticut, to gradually manumit the slaves that were in Connecticut. And so, from 21st century America, we can look back on that and say, yeah, way to go, Roger Sherman and Richard Law. This is an incredibly wonderful piece of legislation, something that Jefferson did not do, of course. One of the interesting questions raised by the War for Independence is Parliament's Act of Toleration in the 17th century forced these very reformed states like Connecticut, Massachusetts, what became New Hampshire and elsewhere, to accept Quakers and Anglicans and other non-congregationalist or non-reformed citizens. So now that Connecticut is no longer bound by this act of toleration, it's conceivable that the state could impose heavy penalties on these dissenting Protestants, ban Catholics altogether, and this sort of thing. So what's particularly telling in a context of a state that's heavily, heavily reformed, again, heavily Calvinist, mostly Congregationalist, is Sherman, working with others, penned a religious liberty statute basically saying that all Protestants will have the complete freedom of religion, and coming up with a form of establishment, what scholars call a plural or multiple establishment, which basically says that you will be taxed to support the church you attend. And so there's still state involvement in that, and I'm not particularly comfortable with that, but at least it's a fairly liberal establishment, so that if you're an Anglican in Connecticut going to an Anglican church, you'll be taxed to support that church. If you're a Presbyterian, you'll be taxed to support that church. If you're a Congregationalist, you'll be taxed to support that church. And so it's a pretty robust protection of religious liberty. Now, you might object, and you would be right to object, that this is protecting the religious liberty of Protestants only. At least a partial defense of that is that there are almost no Roman Catholics in Connecticut in this era. But I still think it's fair to ding Roger Sherman for not having as robust of an understanding of religious liberty as, say, Thomas Jefferson had down in Virginia. And yet I would also suggest this. If we're interested in an originalist understanding of what the American founders meant when they crafted the First Amendment, we can't just go to Jefferson's Virginia Statute for Religious Liberty. Basically, every state came up with religious liberty statutes or constitutional provisions protecting religious liberty in America between 1776 and the adoption of the First Amendment. And so we just need to expand the conversation. We need to look at what went on in Massachusetts with the Constitution in 1780, what went on in Connecticut in 1783, 1784, what went on in Virginia in 1786. We can't just privilege one of these documents over all the rest. We have to look at them all collectively, and that can give us a much better sense, I think, of what the founders thought on these issues. And, of course, I'm just giving religious liberty as an example here. We should do this with respect to any constitutional issue that we're interested in the founders' views or original understanding of.
Yeah, I mean, just thinking about your overall experience, we read Thomas Jefferson and think of the high wall of separation. That's not representative, I think, of where most of the framers were on the question. I think most sort of understood and embraced an indirect power, at least, of religion and politics, and understood that these things, while there shouldn't be penalties attached to one's devotion, and these things were going to be intermixed to some degree.
I think that's exactly right. And even Thomas Jefferson, of course, you're referring to his famous letter to the Danbury Baptist, where he talks about the Establishment Clause creating a wall of separation between church and state. But even for Jefferson, that's arguably a Federalist provision. Later in life, he has a letter which we quote in the Sacred Rights of Conscience, where he's talking, this is into the 19th century, where he says, well, to the extent to which governments should support religion, it should be the state governments that do so. As governor of Virginia, he issued a call for prayer and fasting. When he revised the Virginia statutes, he came up with a bill, or he revised a bill that included stating when governors could issue calls for prayer and fasting, this sort of thing. So I would say, first of all, this metaphor, the wall of separation, is a very unfortunate metaphor. I do think Jefferson wanted a greater separation of church and state than most founders. Most founders wanted the national government to have very little participation in this sort of thing, and certainly they didn't want a national establishment. I think that's one thing they all had in common. I would say to the extent to which they thought government should be involved in promoting religion, establishing a church, they were almost uniformly agreed that it should be the state governments that would do this. But even there was a hot and heavy debate as to whether or not state governments should do this, and many argued for, I think, very good reasons that actually Christianity or religion is a lot better off if the state keeps its nose out of this business. And so they were supporting reducing state involvement because they cared so much about Christianity, they didn't want the state to corrupt it.
Yeah, I mean, it's interesting, too, in this regard, thinking, Madison's Memorial and Remonstrance is also heavily cited for an understanding of religious freedom. But when you read that, as much as I can affirm what he's arguing there, it's sort of a mental construct that he's dealing with. It's a lonely person reasoning with their own conscience, what they're going to believe. But that's not really how flesh and blood human beings approach religion. It's inherently corporate. It's inherently something we do with other people. And it would seem that religious freedom would have to take that into account, which I'm not suggesting you would want to go the way of an established church or something like that. But when we look at Sherman thinking about religious freedom, just sort of reasoning and thinking about what he's doing there, it seems to me there's an understanding of the corporate reality of religion that we don't see with Jefferson or Madison, two men who themselves are, I think, largely post-Christian and their own devotions.
No, I think that's exactly right, which then raised really profound and interesting questions. When the U.S. Supreme Court decided Everson versus the Board of Education, they more or less, both the majority and the dissent, adopted the same argument, which was that we have to interpret the Establishment Clause in light of the founders' views. Jefferson and Madison equal the American founders. Jefferson and Madison wanted a strict separation of church and state. Therefore, the Establishment Clause requires the strict separation of church and state. Very individualistic, very extreme, and completely untethered to American history. I mean, it's just wrong on almost every level. I think to begin with, again, we can question reasonably why include Jefferson in among the two founders that matter when he wasn't involved in drafting the First Amendment or ratifying the First Amendment. Those two are outliers in any respect. I think they were far more tolerant of a cooperation between church and state than the ACLU or Americans United would want us to believe. But all the more significant, when we turn our eyes from those two founders to the rest of the founders, to a George Washington, to a John Adams, to a Roger Sherman, to a Patrick Henry, to a probably not George Mason, but Elias Boudinot, John Hancock, Samuel Adams. We could go on and on and on. We see a very different view of both religious liberty and church-state relations coming into focus. Now, let me just say, lest people fear I'm arguing that we should take their views and impose them on 21st century America, I suppose as a prudential political thinker, I would say America is a far different place today than it was in the late 18th century. And what might have worked, at least tolerably well then, I think wouldn't work at all today. So I'm not arguing for that at all. But just as a matter of history, if we want an accurate account of the founders' views of religious liberty and church-state relations, we just have to look at this larger constellation of founders, and we can't just look at the two founders that are far more attractive to modern academics at first.
It seems to me also on this thread that expanding the conversation along the lines that we're having with, say, Roger Sherman is you begin to have a way to peel back this sort of problem of an establishment clause jurisprudence that was so expansive it proved unworkable, and I think the court realized that, and you interceded in state government affairs in the manner in which the court has done over the past 50 years, and largely you create so many more problems, arguably. And if you look at what Sherman might have foreseen or argued, is it becomes a justification for the court to pull back a little bit on this strict separationist ideal, which the court in certain respects has, although I don't even try to proclaim that I am an expert in this regard, because that jurisprudence itself is so unwieldy now.
Oh, it is, and it's just utterly laughable if you look at the establishment clause jurisprudence out of the 70s and 80s. It's just a crazy quilt of what's permitted, what isn't permitted, because as much as separationists like to talk about a high wall of separation between church and state,
it's impossible.
Really, no jurist or academic has ever tried to catch that out in a literal sort of way, in a sort of way that would say churches should be free from fire codes and shouldn't be protected by fire departments and this sort of thing, right? No one has gone there. Even the Everson versus the Board of Education, everyone agreed on the syllogism, but the court split on whether or not children could be subsidized as they went to private schools, including parochial schools. So, it's just been a crazy quilt. If we're going to take an originalist understanding of the Establishment Clause, I think what that would suggest is the state would have more freedom to do things such as, issue calls for prayer and fasting, fund private religious schools, or fund private religious charities. And then it would become a matter of prudence that citizens of states could debate to what extent we want to do this or not. And that would be a much more honest way of having the debate.
It seems also, which I think is a part of this, and maybe we can get into sort of what's the real Sherman legacy here and what's its distinction. But it seems to me this is something we don't necessarily look to the court to resolve in its Platonic nationalist wisdom. We're willing to live with imperfection and self-government as to what people are willing to tolerate in this sort of, inevitable intertwining of religion and government, particularly in the era of big government, where the government is doing so much.
Yeah, no, I think that's right. And it's tough in some ways, to speak of a Sherman legacy, because I would say you could speak very powerfully of a Sherman legacy for 150 years, where we have a national government that has a lot more power than it had under the Articles of Confederation, and yet was still fairly limited, where most things government did would be done at the state or the local level. And Sherman would say 3 cheers for that: criminal law, education, poverty relief, promotion of morality and religion. These are things that should be done at the state or local level if governments are going to do them at all. And in some cases, maybe government should just withdraw from that field altogether. Obviously, we see a massive shift in the 20th century because of what is in the 19th Amendment that give the people of the states the ability to elect the senators. And then, of course, a just complete overriding of our Federalist jurisprudence in the 1930s. And so America has become something that I think Sherman would find almost unrecognizable in terms of our constitutional organization today. But I think many of the founders, with the exception of maybe James Wilson and Alexander Hamilton, would be appalled, including a James Madison, where if you were to see the basic unlimited power of the national government today, the unlimited prerogatives of the executive, I think a number of the founders would be appalled and would call for a significant reduction in the power of the national government, a return of this power to the states, and then in some instances perhaps even getting the states out of this business altogether.
What we have then is maybe the practice of Roger Sherman. We're going to look to the practice of Roger Sherman as a way of reforming our national government and all of its present woes.
I think so. And the arguments he made in support of these constitutional provisions and other provisions that he made. So I think there's a coherent political theory there that is, I think, far better than the political theory we've ended up with. My first book, and you mentioned I've also co-edited the collected works of James Wilson. James Wilson would probably love where we're at today. He wanted this incredibly powerful executive, incredibly powerful national government. He thought states were just sort of minor nuisances that maybe we should just draw the boundaries for the state lines because they don't really matter. James Wilson was from Scotland. He really didn't get America in the 18th century. Roger Sherman was very much a product of Connecticut, committed to protecting his state and his people's way of life, and I think that's a far superior approach to American constitutionalism than, say, James Wilson.
Mark, thank you so much for joining us. We've been talking with Mark David Hall, the editor of a new volume, The Collected Works of Roger Sherman, published by Liberty Fund Books. Thank you so much.
Hey, thank you very much, Richard.
This is your host, Richard Greinch, and you have been listening to a podcast that can be found at libertylawsite.org, where you can subscribe, comment, and find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org.